Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zayas presiding as session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have 4 cases on the docket this morning. 3 are scheduled to argue. 1 has submitted on the briefs. The first case that we have is State of Ohio versus Eccles, and that's case number C220133. That case has submitted on the briefs. The next case we have is State of Ohio versus Fleming, case number C220275. Attorney for the appellant, if you can identify yourself and you're ready to proceed.
Laura Peters on behalf of the appellant R.S. Fleming. I'm ready to proceed.
Okay. And attorney for the appellee, I see that you are ready to proceed, right?
Yes, ma'am. Jennifer Bishop for the City of Cincinnati, ready for argument.
Okay, thank you. The next case we have is State of Ohio versus Jackson, case number C210634.
Your Honor, Paul Kraus, ready to proceed for the appellant.
Good morning.
Your Honor, City of Cincinnati, Connor Wood, ready to proceed for oral argument.
Thank you. And the last case we have for argument this morning is Collier versus Smith, case number C210662.
Your Honor, Nathaniel Truett on behalf of the appellant, ready to proceed.
Good morning.
Your Honor, Marcus Cohen on behalf of the appellant, ready to proceed.
Thank you. Good morning. All righty. So State versus Fleming. Attorney Peters, would you like to reserve time?
Yes, Your Honor. 5 minutes.
Whenever you're ready.
May it please the court, my name is Laura Peters. I'm with the Hamilton County Public Defender's Office, and I represent R.S. Fleming in this matter. Actually don't plan on taking up much of your time on this case. I know there's 2 assignments of error presented. We plan on submitting on the second assignment of error unless the court has any questions regarding the issuance of a fine without notice at the hearing or being. So basically what we're here today is to discuss service. Mr. Fleming was charged with violation of a protection order that was issued pursuant to 2903.214. In this case, Mr. Fleming mother requested a civil stalking protection order, or I like to just refer to it as a CPO. So she obtained a CPO in April 17th of 2020. The incident in this case did not occur until May 7th of 2022. The ex parte order by that time had been expired for over a year. However, following the ex parte order,
And that's not contested.
that's not contested, correct, and we are not contesting that he was served with the ex parte order. The question is but that ex parte order was not valid at the time of the incident. So service of the ex parte order is really a red herring in this case, because you have to have a valid protection order and in existence in order to be found guilty of violation of a protection order.
Well, there was an order. There was a protection order in place.
Correct, Your
right?
Honor.
And
Yes.
you're just saying that that particular order was not properly served on him.
We're submitting that there was no proof of service as required by the Ohio Supreme Court on State versus Smith, which was cited in our brief, that there has to be proof of service of the order. And in this case, there was no proof of service of the full CPO issued. It was heard in front of a magistrate. The magistrate entered an order, and that was adopted about approximately a month later in May of 2020 by the trial court. However, there was actually no proof of service of that order on Mr. Fleming.
Isn't there an exception to actual service on the protection order?
Your Honor, yes. The statute was amended after State versus Smith was decided by the Ohio Supreme Court, and 2919.27, paragraph D, provides 2 exceptions to that. 1, if the defendant is shown a copy of the order, and 2, if a judge, magistrate, or law enforcement informs the respondent of the CPO, of the existence of the CPO.
You have to have both?
One or the other.
One or the other.
One or the other.
So basically a family member could show him a copy of the order, and that would be good enough.
I don't know if that's been tested, but it just says that the defendant has been shown a copy of the CPO. In this case, we didn't have any testimony.
Doesn't it also require reckless violation?
Yes, Your Honor. Yes, in order to be guilty, he has to be recklessly have violated the terms of the protection order. But in this case, we didn't have any testimony. There was no testimony, and the state never argued below that one of the exceptions to service under the D paragraph was proven at trial. So we had the mother saying she told him, that she knew he was aware of it because she told him about it, but her testimony is basically as simple as that. We don't have any idea of when she told him, which order she was talking about, or whether or not he even heard her or what the circumstances are.
We don't know that she was talking about the full order.
That's correct. If you examine her testimony, she just says, he was aware of it. But there was yes, you're correct, that she didn't say, oh, we had this discussion in June of 2020, or even after the ex parte order, or sometime later, like, hey, you can't be here because you're still under an order.
Do you think it would have been
Or
enough?
she actually would have to have, and the fact is, she would actually have to showed it to him.
That
and
was
she
the question.
she didn't actually show him one. All we have is her testimonies that she told him about an order, but we don't know which order she's talking about, and we definitely don't have any testimony that he was shown a copy of the order.
Do you think that would have been enough under the exception if she would have said, yes, I showed him a copy of the order?
I believe to me it's questionable, but since we have absolutely no evidence on that, I'm not too worried about that exception to the service, because there's absolutely no testimony in this case that my client was shown the order, the full order. When we're talking the full order, not the ex parte order.
Counsel, your client didn't attend the final merits hearing, isn't that right?
That is correct, Your Honor.
And so doesn't this create a loophole where people would be disincentivized to attend the final merits hearing so that they don't have knowledge of the order?
No, Your Honor, I don't believe so, because if all we had to do, what we have is he has to be served with it. So they could have done personal service, which that's not required. I will admit that's not required under Civil Rule 65.1. Requires mailing after the initial service, which was done personally by the sheriff. You can, under 65.1 C3, service can be established by mailing. However, in this case, we don't have any proof of mailing. So again, it comes down to service. So no, it doesn't incentivize, because the statute calls in for mailing. And in a case decided by this court, which is not cited in my brief, but I can give you the citation, it's Cincinnati versus Phillips, 1st District, number C130460, 2014, Ohio 2614. In that case, the state had attempted to prove service with a document from the clerk of courts. However, in that instance, the city had, or the state had failed to properly authenticate the exhibit, so it was excluded. And in that case, this court reversed the defendant's conviction for violation of a protection order because there wasn't proof of service. So we don't even have that here. We don't even have the state offering any document from the clerk of courts to say, hey, we actually did mail this. So we have no evidence of service. Unless the court has any further questions, I'll reserve the remainder of my time. Thank you.
Jennifer Bishop for the City of Cincinnati. The decision of the trial court must be affirmed because the evidence was sufficient to prove that the protection order was violated. The decision has to be affirmed because it did not violate the manifest weight of the evidence. To counsel's specific point, there is evidence in the record that both the ex parte protection order and the final protection order were served on the defendant. The ex parte order was served by personal service. The final protection order was served pursuant to the civil rules of procedure by mail. And State's Exhibit 3 that was introduced in the trial court establishes that. The reason that
What was State's Exhibit 3?
it's the final protection order,
And how does that establish it was served by mail?
because the terms of that order say it was served by mail. The last page of State's Exhibit 3 says served by mail,
So when you say served by mail, you mean served by regular mail?
regular U.S. mail.
Do we have any evidence as to what address that was served to?
I would say that the address on the order is the address that it would have been served at.
So the address that appears on the order itself is the address that it was served to?
Yes, ma'am.
And we would know that from the order itself?
Correct.
Okay.
But the reason that the ex parte order is important is because the standard is recklessly violate the order. And in this case, the law in Ohio is that once the defendant is on notice that that order exists, then until that defendant is given notice by another court, he still has to abide by that order. And in this case, I think it is clear that the defendant had personal notice of the ex parte order. The defendant had U.S. mail service of the final protection order, and the fact that the defendant violated the order by going to his mother's residence is sufficient proof of violation of the order, proof that the testimony was not against the manifest weight of the evidence, and this court should affirm the trial court verdict.
The ex parte order, though, was expired at the time of the
Well,
offense here, right? So
Well-
why does that even come into our calculation at all?
because it gives the defendant notice.
But it was expired.
Well, I don't know that it was expired. I think that the final order takes the place of the ex parte order. But the standard is recklessly violated. And the case law, I believe, says that once you're on notice that a court has issued this order, you're reckless if you don't inquire as to, is the order still in place? Am I violating it by this particular behavior?
So you don't believe that, so if there's an ex parte order that he was properly served with, are you saying that he wouldn't even have to be served with this subsequent full order? Because he's on notice of the ex parte order?
Well, the standard, I believe, is reckless, and once he is aware of that order, then I think he has to proceed in accordance. I think the rules are what the rules are, and the civil rules are is that regular mail service is sufficient after the person has personal service of the initial order. And another important part of the facts of this case is that the personal service order gave him notice of the time, the date, the location of the final hearing. So he chooses not to know, and that makes him reckless in disregarding the court's order.
I want to return to State's Exhibit 3. The order instructs the clerk to send the order out by regular mail. Do we have any evidence from the clerk that the order was actually sent out?
That is not in part of the exhibits that was in front of the trial court.
All right, thank you.
So,
You had stated that because he was served with the ex parte order, that he was to comply with the terms of that ex parte order until he was to receive the permanent order. Is there any case law that you can point to support that?
yes, ma'am, the case is cited in my brief, and it's not a popping out at me right now, but I did cite that case in my brief. Oh, it's Hall. In State v. Hall,
Okay.
it's the case that was remanded after the Supreme Court decided State v. Smith. And what the appellate court said in State v. Hall is the fact that the defendant was on notice of the prior, the ex parte orders that made the defendant reckless in not inquiring as to whether the order was still in effect.
Was the ex parte order in effect at the time of the offense in that case? Or had it expired, like this case?
I'm not going to say that I remember because I don't. But the important thing, I think, from State v. Hall is that once the defendant is on notice of the order, he becomes reckless when he violates the order without inquiring as to whether or not the first order is still in effect. So the decision of the trial court must be affirmed. Not arguing the second issue because counsel submitted it.
And just as a little footnote, the ex parte order, did it contain the date, time, and place of the hearing?
Yes, ma'am.
Okay, thank you.
That's State's Exhibit number 2.
Okay, thank you. All right, so you have 7 minutes.
Thank you, Your Honor. Judge Krause, I'll answer your question regarding Hall, and the answer is the ex parte order was still in effect at the time that Hall violated the protection order. So, in fact, the Hall court said that because Hall argues he did not receive the civil notice, however, that did not relieve him of the responsibility to abide by the terms of the ex parte order, which he acknowledged stated that it was in effect until July 26, 2013, and in that case, the offense occurred before the expiration. So that I would submit that Hall is it's distinguishable from our case.
Are you familiar with any case that extends any responsibility to the respondent with regard to an ex parte order after the expiration date of such?
No, actually, I would say Hall says to the contrary. So unless the order was canceled or terminated, the ex parte order, then he still had to abide by it while it was still in existence. In this case, Mr. Fleming, yes, was served with the ex parte order, but he also was, as part of that order, he was put on notice that it expired on April 17th, 2021. Again, this incident didn't occur until May 7th of 2022, so over a year later. So he would have to have been served with the full order.
Now,
Now-
the state's main argument is that because the permanent order states that it is to be served by regular mail, that suffices to establish that it was served. Can you address that, please?
Yes, Your Honor, I was actually just getting to that, so good anticipation. State's Exhibit 3. So what you have is the front page, and that's actually the trial court's adoption of the magistrate's order. So the last page that counsel on the other side referred to as the last page ordering service by mail is actually the magistrate's order. And the magistrate's order was ordered to be served by mail pursuant to Civil Rule 65.1C3. However, we don't actually have proof that that was done. And also under 65.1 F3C(i), a magistrate's order is not effective until adopted by the court. So that, if that was mailed out, it was not an effective order, it wasn't a valid order yet. So we come to the front page, which is the trial court's adoption, and that actually says.
What's the lapse time between?
There was a month.
entry? Okay.
A month.
Between the entry of the magistrate's order and
Yes.
adoption and signature of the trial court?
Yes, approximately a month. So it was, the trial court's order was entered on May 28th of 2020. It looks like the magistrate's order was entered, I'm sorry, so it was 3 weeks, May 6th of 2020. It looks like that's when I see an enter date on the magistrate's order. However, the trial court's order wasn't served pursuant, doesn't say it was to be served by U.S. mail. It says, notice of final appealable order, the clerk shall serve notice pursuant to Civil Rule 58. Now, Civil Rule 58 says the clerk shall serve the parties with the final order unless the party is in default of appearance. Mr. Fleming never appeared in this case. So we actually don't know if the clerk served him because he never made an appearance in the stalking case, because he wasn't present at the hearing, and he didn't submit any responsive pleadings. So we actually don't know by the face of the entry whether or not this was actually mailed out by the
Let me
clerk.
make sure I understood what you said, because I'm not sure I did.
Sure.
So Civil Rule 58 says that it's to be served unless the respondent failed to appear? Did I understand that correctly?
Okay. Civil Rule 58B says, when the court signs a judgment, the court shall endorse thereon a direction to the clerk to serve upon all parties not in default for failure to appear. So, we don't actually know if the clerk would have served Mr. Fleming with this because he never made an appearance in the stalking case.
But it sounds like he's not required to be served, at least on that language.
Based on that language. So, again, State versus Smith requires proof of service.
Counsel, the complaint in this case alleges that Mr. Fleming violated a CPO issued on April 29th. Were any of the orders that you just referenced issued on April 29th?
No, Your Honor, it was not. I think it was probably a typographical, because April 29th was the date of the full hearing. So I'm wondering if it was a typographical error.
At any point during the trial, did the state move to amend the complaint in conformity with the actual date of the order?
I don't believe so, no, Your Honor.
I'm a little confused, though. So we have a magistrate order that says to be served by mail.
Correct. But we don't have any proof of that was actually mailed out.
Well, that's the key, right?
Right, it is the key.
You talk about the judge and Rule 58 and
Yeah.
everything, but, if it had been served, if the magistrate order had been served, then, and we had proof in the record, that's the key to this case, right?
Correct.
So I was just getting kind of
Yes,
confused
no.
about what you were saying about the judge and Rule 58 and everything. The bottom line is what you're saying is that there was nothing presented at trial, even though the order says to be served. Your argument is there has to be some sort of proof of service that is an exhibit at trial.
Correct. Yes, and I'd refer back to the Cincinnati versus Phillips case that I cited to you today, and I can supplement the court with that if you wish. So I'll put a notice, a supplemental authority. But yes, so ultimately, the bottom line is State versus Smith requires proof of service. In this case, there was no evidence, and counsel on the other side acknowledged that there was nothing from the clerk of courts submitted at trial to show that they actually mailed out the final protection order. So without that, my client you should reverse and discharge him.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and we wish you both a wonderful afternoon. We're going to take a 1-minute pause as we're doing a switching of judges here. Okay. Good morning again. All right, so now we have State versus Jackson. Good morning.
Your Honor, I'm Paul Krausshore, and I'd like to reserve 3 minutes for rebuttal.
All right, 3 minutes.
Your Honors, this case has two major issues. First, there is no proof of intent to harm, so we have a sufficiency and manifest weight issue. We also have an issue with the statute itself, which I would posit lacks sufficient guidance to law enforcement to be able to make a decision or to back up the decision if, as in this case, some interloper goes around the contact officers and says to the sergeant at the station, why didn't you charge the defendant? I want you to charge him. And
That sounds to me like a constitutional challenge, and that was not raised at the trial court.
That's correct, Your Honor. This would be a plain error issue for the court to take under submission if the court finds that it's a plain error. Mr. Bennett did not, in fact, raise that. He stuck with the manifest weight and sufficiency.
Your brief raises an issue with the definition of physical harm in the statute and how it's been judicially construed over time.
Yes, Your Honor.
What definition do you propose with respect to the term physical harm?
I don't think I can, Your Honor, because I can see that the problem with the way the knowingly intending to cause harm was applied in this case, but I don't know a way around it, and I'm sorry. I've thought about that a lot. I can't. I think the language is deficient under the Sessions case because it doesn't provide a meaningful definition, but I don't know a better way to do it, and that's not for lack of trying. But I don't know that anybody could define it better. If we stuck with the assault and said if you're found guilty of assault and it's a domestic case, that might solve it. And of course, there was no assault charge. In fact, the former wife, Mrs. Jackson, Kristen Jackson, said that he assaulted her, but never provided any details of that up until the trial. So the contact officers did not have anything to base a decision on, which I think is why they didn't charge Mr. Jackson at the scene, and they just counseled them because what appears to have been said, and this is from the cover officer, was that they were wrestling over a phone, which isn't an intent to harm. It's not a strike, it's not a hit, anything like that. Now, when I was in my first marriage physically assaulted by my first wife, she intended to cause me harm by punching and other things. But that's that wrestling over a phone doesn't seem to match that. So,
Well, I think there was a little bit more testified from the wife, so isn't it ultimately a credibility determination?
she did ultimately say that, and that's the problem with them going around the officers, is what she told the officers. Now, the contact officer never testified. Defense managed to get the cover officer there, who said it didn't seem to be a criminal offense, and so that they didn't provide anything other than counseling. But we don't know what she said to the contact officer. She admitted that she never said in the CPO or TPO hearings any details about him striking her or anything like that. She just said they were wrestling for her phone. At what point does wrestling become an intent to harm? That I don't think was ever really explored by the prosecution. And Mr. Bennett tried to raise that, but he didn't have, it turns out, I think he thought he had the officer there to testify, but he just had the cover officer. But that was the attempt that the defense made, was to solve that problem, because otherwise...
Does that really matter, though? I mean, the trial court, so Mrs. Jackson testified that he jerked her around, he hit the back of her arms, he squeezed her arms, he scratched her chest, although that might have been unintentional, but, saying that hit her and squeezed her and knocked her out of the bed, the trial court chose to believe her testimony.
Yes, ma'am.
So does it matter?
I do, because none of those words are inconsistent with wrestling. I mean, lots of wrestling happens in lots of contexts. Is squeezing, lunging, tackling necessarily implicate attempt to harm? And that's.
But she testified that he hit the back of her arms.
Well, again, I've been hit many times. Being hit in the context of, it's contextual. Being hit in the context of being assaulted, being physically attacked by someone who's attempting to hurt you, I think is very different from being struck while you're wrestling for something. If they're fighting over a phone, and really the people who were best positioned to deal with that thought that there was not a criminal offense, and they're the ones that had the chance to interview both the parties at that moment before they get a chance to consult with retired police officer father.
But why does that matter? I mean, we have her testimony, we have the pictures of her bruises.
Yes.
Why does it matter that her father went to the police station?
Because the question really is, on the first part, it's intent, is what, as I read this, I think one of these parties was in love and the other party was not in love. The party that was not in love was attempting to use the criminal justice system to achieve keeping him away from her and her children and achieve the domestic violence conviction and thereby achieve an advantage that she wouldn't have in a civil protection order or just from splitting up. And so the best evidence of what actually happened was the conversation with the police officers at the scene and not what was told by her father to the desk sergeant. I mean, the officer who signed the complaint wasn't either of the officers who was there. So this is a sort of an interloping involvement after there's time to figure out what to say.
So if we follow what you're saying and take it a few steps further, basically what you're saying is that if the police do not press charges when they first visit the scene of an alleged crime, then they can't press charges later?
Oh, I think the best evidence of what the intent of the parties was, if the state had called that contact officer and they discussed with him what happened and what was said that night.
But he wasn't there. Mrs. Jackson was.
The contact officer was there immediately after.
But he wasn't a witness to what happened.
Correct. And the only witness to what happened was the son, who said that they were wrestling and arguing. So we don't know for sure what happened. Yes, she said, well, what she said at all times up until the trial was that they were wrestling or that he physically assaulted her. But that's a conclusion, not a statement of what was actually happening. So if they're wrestling for an object, that's not him intending to harm her, that's in him trying to get the object, is how I would.
Counsel, is it your position that if a person is trying to take a piece of property away from someone, and in the course of doing that, hits them, squeezes them, knocks them to the floor, that is not domestic violence? Is that your position?
Phrased that way, it is not my position. My position is that when two people are wrestling for something or attempting to achieve some other goal, that doesn't demonstrate that one of those parties is attempting to harm the other party. Now, harm can result. Happens all the time in high school athletics, where in wrestling or football or anywhere else, where people are trying to get a football, they're not trying to harm each other.
Well, this wasn't a high school athletic field, it was someone's home, right?
Yes, ma'am. Yeah, it's an imperfect analogy, I'll agree. But the key is, what was the intent of the tortfeasor or the defendant? And the best evidence of what that was what was said and done at the time or shortly thereafter. As soon as we have Kristen Jackson's father getting involved and going and creating the criminal case, I think it becomes very untrustworthy what was said, and it involves that whole other process. The statute, because it's so vague, has to put the initial decision on the police officers, and they're the best ones to have made that call, and they didn't think that it was a domestic violence situation, clearly, because they didn't do anything.
Do we have any information as to why the contact officer did not testify?
We don't. I think Mr. Bennett thought that he had the right officer because without going outside the record, his response within the record to the cover officer seemed surprised at the fact that he didn't have the guy who made that call. I think he thought from that conversation that he had was that he had the right officer, and had the state called the contact officer, we would have had the answers to the questions. As it is, we have a situation where we don't really know what she said to the contact officer, because the cover officer, I think, was talking to Mr. Jackson.
Counsel, you have about a minute left.
Thank you, Your Honor. I'll hold except for other questions.
No, there might be more.
I do have one additional
ma'am.
question. I noticed in the record that there was body-worn camera footage disclosed to the defense. That evidence would have been available to the defense to present at trial, right?
I actually had not noticed that, and I didn't see that in the record, and it was not, in fact, introduced. So I did not get that from Mr. Bennett. So
All right,
if it
thank you.
exists, thank you.
Good morning.
Morning, Your Honors.
I'm going to start off with a question.
Yes, ma'am.
So appellant argues this morning that because the arriving on the scene officers did not charge, that can only mean that they have determined that there was no domestic violence that had occurred. Can you address that?
Yes, Your Honor. I believe what this may have been is a situation where the evidence was able to be presented in a more cohesive manner to an officer at a later time. In a situation where a survivor of domestic violence is making that report to the police, particularly in close proximity to the time that the event occurred, it is entirely likely that Ms. Jackson's emotional state at that point, her ability to convey exactly what had happened to the responding officers, was not able to get the information across as clearly at that point. It could also have been a situation where, unfortunately, you do run into situations where officers just believe that they don't have enough probable cause at the time that the information is presented to sign a charge. Now, that does not mean that probable cause to sign charges cannot develop. In this case, it very obviously did, because you had not just Ms. Jackson telling the police what happened the night of. You had photographs of the injuries that she sustained in the incident that were able to be presented at a later date. You had the testimony of her son, Jaron, who saw the incident and was able to be presented at a later date.
And speaking of which, appellant stated that both wife and son's testimony was about wrestling. How would you respond to that? Is that what the record establishes?
Your Honor, I don't think the record establishes that this is merely wrestling. And I think it goes more towards the issue of knowingly. If you're looking at the statutory definition of knowingly, it is any conduct, regardless of purpose, which the offender knows will cause a certain result or is likely to be of a certain nature. In this instance, what defense counsel is referring to as wrestling is grabbing Kristen Jackson by the arms severely enough to cause bruises, knocking her off of the bed onto the floor, grabbing at her, trying to get the phone that she is attempting to conceal from him with her body. In so doing, he scratches her chest. I don't think you can qualify this as just wrestling. Reaching out to grab someone who very clearly does not want to hand over a piece of property, knocking them off the bed onto the floor,
Because
having to
ultimately,
use.
his argument, and he didn't use the word consensual, but I'm going to add the word consensual, that there was consensual wrestling that took place, and that's what actually happened. And so he was, addressing it from an intent perspective.
And, Your Honor, I think that would be a mischaracterization of the evidence that was presented at trial. It was very clear from the testimony of Ms. Jackson that this was not consensual. She did not want to give the phone to her husband. It was not a, play wrestling match or anything like that. She was screaming for help, and that's what
But
prompted
even
her
if it
sons to
was,
come
how
up.
would intent play into it?
Your Honor, in this case, I think you have to look back at the definition of knowingly. If what you are doing at a particular time, regardless of your purpose in doing it, if you're aware that the conduct you are engaging in is likely to cause a certain result, in this case, physical harm to another person, I think that there is an argument that that would qualify as an assault, or in this case, a domestic violence. Yeah, obviously, it's going to be contextual, something that is, I believe, if you were to argue that it's consensual between both parties, I think then you would have to examine that a little more closely. In cases like this, where it is very clearly not a consensual encounter between the two parties, I think it's very clear that this is an assault or a domestic violence situation.
Wasn't there evidence that Mr. Jackson was downstairs and then became aware of something on the cell phone and then came upstairs for that purpose? Could you address that part of the record?
Yes, I believe the testimony from Ms. Jackson, if I'm remembering correctly, was that she was upstairs in their bedroom watching something on her phone. The defendant all of a sudden came upstairs, was upset about some kind of app that he believed Ms. Jackson had on her phone, and that was what prompted the argument and then eventually the physical altercation where the defendant was trying to get that phone from her to investigate that. So again, something that is very clearly not a consensual encounter because it turned into an argument based on something the defendant believed to exist.
And do we know if the minor son was interviewed at the scene that night?
That I actually am not sure of. I can't recall from the record whether he was ever interviewed by police or if it was something that came to light after the charge was filed and through the officer's investigation and the prosecutor's investigation preparing for the case. That was something that was discovered that the son witnessed at least part of the altercation. I'm not sure if he spoke to the police that night.
Could you also address the role of police discretion in making an arrest in this situation?
So speaking as a prosecutor, in particular a domestic violence prosecutor, I will say that officers do have a large amount of discretion in deciding whether or not they have enough probable cause to file a charge. It is not an unusual circumstance where if an officer doesn't have enough probable cause, that they will advise the victim if you think of anything else or if you have any other things that you think of later that you want to tell us, come back, make a report, we can supplement, and if at that time there is enough probable cause that has developed to sign a charge, we'll sign a charge. I believe in this case, because there was just Ms. Jackson there at the time, there's no evidence in the record as to what her mental state was at the time that the officers were talking to her. There was no evidence as to whether or not they ever had an opportunity to speak with her minor sons who were there, who saw at least part of the incident. The discretion of the officers at that point, based on the information they were able to obtain, I think is part of the reason why the charge was not filed until a later time, at which point that evidence was able to be presented sufficiently for them to file a charge and feel comfortable doing so.
Mr. Jackson has raised a challenge to the statute involving the definition of physical harm. How do we know when there is enough physical harm?
So I think, despite defense counsel's assertion, the language in the case law in the First District is very clear as to what defines physical harm. Statute says it's any injury, illness, or psychological impairment, or physiological impairment, regardless of its gravity or duration. This court in Daniels said that simply inflicting pain is sufficient to present evidence of physical harm. At that point, it's a determination that the court takes over, goes to manifest weight as to whether or not that whatever the injury is or whatever the pain is or whatever the physiological impairment is that is presented rises to the level of physical harm. In this case, in particular, just speaking specifically to this case, you have not only the testimony of Christian Jackson, where she said that after the defendant grabbed her by the arm, she had stinging, burning pain in her arms. You also have the physical evidence. You have State's Exhibits 1 through 5, which show the bruising on her arms, the scratch on her chest, and you have the testimony from her son, who said that he could hear her screaming for help. So I think all of those pieces together rise to the level of very clear physical harm in this case, and it is any injury. And the legislature drafted the definition of physical harm specifically to say any injury, illness, or physiological impairment.
And I think that's where perhaps the argument is of the vagueness. Now, appellant stated this morning that because it wasn't raised at the trial court that we should review on plain error. I would like your position on that, whether it's plain error, whether it's waived.
Your Honor, I would argue that it's waived. This is very clearly a constitutional issue. If you're arguing about the definition of a statute, whether a person can be arrested based on the definition that is provided in the statute for physical harm, that is a constitutional issue. You're talking about deprivation of liberty at that point. The fact that it was not raised at the lower court means that it's waived. Even if you're going to argue that this is a plain error situation, I think that the definition of physical harm and the case law that this district has provided does create a strong enough definition of what physical harm is to put defendants on notice of what exactly is prohibited under the law. So even if you were to take this argument as it is on a plain error standard, in this case specifically, and I think in most cases that come across for domestic violence, for assault, for anything that operates under that physical harm definition, the statutory definition and the case law together do provide a sufficient definition to put defendants on notice.
Counselor, opposing counsel suggested that the survivor's father interfered with the investigation, and that's what got the ball rolling in this case. And can you please address that?
In terms of the conviction, I believe it's irrelevant. The interference, if we want to call it that, of the victim's father in being able to communicate with the officers to at least get charges started does not affect whether or not there was sufficient evidence, whether the evidence satisfied the manifest weight to sustain the conviction. It doesn't matter who got the charge filed. The court, with the evidence that was presented, believed that there was sufficient enough evidence to convict on the domestic violence charge. So I believe that it doesn't matter if it was Christian Jackson and the officers signed charges that night. I don't believe it matters if it was her father and the charge was signed a week, a month, a year, whatever it may be later. There still had to be evidence presented at trial to satisfy the state's burden of proof, and it did so.
Thank you.
You're welcome. Your Honor, for those reasons, City maintains that this conviction should be sustained. There was sufficient evidence presented to sustain the conviction. It is not against the manifest weight of the evidence that was presented, and moreover, the statutory definition of physical harm is sufficient, both in its statutory definition as well as with the case law supporting, to uphold this conviction as a matter of law. We will ask that you do so.
Thank you.
Thank you.
Thank you, Your Honors. On the question of the standard of review, in my brief, I asserted that it was de novo under Holzmeyer versus Hospice. The state didn't, or the city didn't address that. I actually think it's plain error, but I don't have authority for that. If they had disagreed with me, I might have been prepared to address that here, but I really tend to think that it's a plain error issue. I think as my understanding, the facts, Judge Bach, the police called Mr. Jackson back. When he got there, I believe the record shows that Mrs. Jackson's brother and sister-in-law, or sister and brother-in-law, were there, and they were all together. There was no indication of the police officers exactly who they spoke with, but I believe that everybody was there and available, and the officers were there for quite some time. So at least I don't know if they actually did, but they had the opportunity to speak with the children. But we just don't have the report of the contact officer. On the question of physical harm, I think we're talking in a circle, because it's not whether physical harm occurred, but whether the defendant intended to cause physical harm. And I think
Doesn't that
leaves-
come down to likelihood?
I don't know that he engages in contact that's likely to cause physical harm, then he intended to do that. Did he know that his wrestling his ex-wife for the phone, or I guess his then-wife for the phone, was likely to result in the physical harm? I don't think he testified that he didn't intend to cause her physical harm. And she, prior to the trial, didn't say any of the things that she said at the trial. She just said that he physically assaulted me in the TPO and CPO that she admitted. So I think we're left with this question of the manifest weight and the sufficiency. And I think in that case it goes to dismissal, because the state has the burden of proving that he did intend, and I think the record does.
Well, the statute doesn't say that. The statute doesn't require intent, it requires knowledge, and there is a difference.
Well, physical harm means any injury, illness, but no person shall knowingly cause or attempt to cause physical harm is 291925A, isn't that what?
Right, knowledge, not intent.
Well, knowingly cause, but can you knowingly cause if you didn't intend to engage in the conduct that causes it? Isn't knowingly,
He intended to engage in the contact. He may not have intended to hurt her, at least that's what you're
Right.
saying.
Yes, ma'am.
But he intended to engage in that contact.
he intended to get her phone, is how I.
He intended to do the actions that he did. It's not like he, fell out of the bed and fell on her and caused her harm.
Yes, ma'am.
He intended to grab her and to wrestle with her. So the
Right.
contact was intentional, or the conduct was intentional.
His conduct was intentional, but did he know the consequence? Right? Did he know that it would cause the physical harm?
Or did he have reason to know? It's not just did he
Right.
know.
Yes,
It's did
ma'am, I
he
would
have
agree with
reason
that.
to know?
Did he have a reason to know that wrestling his wife for her phone? See, if this was two guys, we wouldn't be here.
Well, she testifies that he knocked her out of the bed. She testifies that he jumped on her back. So if the trier of fact believed that, which it appears as if they did, then they believe that he should have known that was going to likely cause physical harm.
I don't know that's consistent, Your Honor. People, boy, I can only put this in from my background. When two guys wrestle for something, one of them necessarily is going to jump on the other's back. I mean, in fact, in the mat, you start that way. You start on each other. The one wrestler starts on the other one's back. I don't have enough ability to elucidate it any better than that. I don't know that necessarily means you're intending to harm them or knowingly harming them.
Well, I think that we can clearly differentiate two people involved in a sport that's a physical contact sport versus two spouses involved in an altercation.
I don't know, not to be flippant, but necessarily there is a lot of contact, an unusual degree of contact between spouses that there is not in a normal life. So is this shades of extent of contact, right? I have contact with my wife in a way that I would not have contact with any man, and yet I have contact with, it's a continuum of contact, or maybe a circle of contact,
I appreciate your advocacy. You have about 30 seconds left.
Thank you, Your Honor. Last issue, I would go back to the interference of the father. Clearly, the case would not have existed but for that. And it's the retired police officer going around the contact officer's decision. That's what strikes me as the worst, as the primary issue here. We had a decision. We don't have any new evidence. We do have pictures of the consequences, but I don't think that changes what the evidence of the intent of the parties was at the time or what they were attempting to do. So I would have to end on lack of an appropriate system for dealing with that and allowing the father to go around the decision of the contact officer. Thank you, Your Honor.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. Have an amazing afternoon. Stay dry. All right, so now we have Collier versus Smith. Whenever you're ready. How are you doing this morning?
Well, thank you.
Now
Your
we
Honor.
get to see you on the other side of the podium. Congratulations.
Thank you, Your Honor.
Would you like to reserve time?
3 minutes, Your Honor.
All right, whenever you're ready.
May it please the court, the juvenile court's custody modification in which it switched full custody from Ms. Collier to father, it should be reversed because it was premised upon mother having voluntarily left the children with father for several months at the beginning of the pandemic. And it rewarded father for his failure to return the children after she withdrew her consent. And despite her having filed 3 motions for contempt, a 4th motion for an emergency hearing, and despite an intervening court order instructing father to return the children.
Mr. Truitt, the magistrate's decision, or possibly the judicial entry, or maybe even both, said that the father was attempting to return them, but mother wasn't available, and commented that he was attempting to work with her to work out these issues, but she was not. Being that we don't have a transcript, how are we supposed to review that?
Your Honor's point is well taken. I think if we look at the case in total, though, no mother I know would go through this much effort to file these motions, to represent herself pro se, to request an emergency hearing, simply not to show up at a time of transfer. And I think there's some insight into specifically what father was alleging. I think it's the last page of the court's order, where the court just references that father alleged that he showed up to return the children, but that mother was not there. There's no suggestion that he had adequately communicated with mother beforehand or that the two had agreed on a time. I recognize that we're constrained because we do not have a transcript, but I would ask the court to look at the record in total. And for that reason, I think it's helpful if we maybe step back and take a look at how this case began. In 2019, with the initial custody award, the juvenile court awarded mother full custody, finding that she was the more truthful parent, that the children had mainly been raised by her, that father had done little to be involved in the children's lives, that father's request for full custody was primarily motivated by his desire to avoid financial assistance, and I think most importantly, that father had begun undermining mother's authority and manipulating the children against her.
All that being the case, then why would she drop off her children to the father for months on end?
Unfortunately, the record does not shed light on all the reasons. What I believe is either in the record or conceded by the other side is that this coincided with the beginning of the pandemic and the shutdowns. But I would note that mother's consent to leave the children with father was only for 4 or 5 months. And under the,
So is it your position that that's not sufficient for a change of circumstances?
yes, Your Honor. Under Ohio law, the change needs to be both substantial and ongoing. And I am not aware of any Ohio court that has found that a several-month change in which parent the children are living with is sufficient to constitute a change in circumstances. Moreover, I believe the magistrate erred by looking at the remainder of that time that the children were with father after mother withdrew her consent. I don't think there's any question but that mother did in fact withdraw her consent at around July or August of 2020. And so to give that...
Entries read a little differently on that issue, on whether there was, as
I'm
to what
sorry.
occurred after the initial period that mother concedes was consensual.
I'm sorry, Your Honor, could you rephrase your question?
I think the record shows a little different, that there's differing perspectives as to after that initial 5-month period of what occurred.
Yes, that is correct, Your Honor, but I think the record is uncontroverted that mother was not consenting to father having the children for the remainder of that time. The contradicting evidence in the record goes to whether father put enough effort into returning the children, whether mother cooperated with father in facilitating that exchange. But I don't think there's any evidence in the record to suggest that mother had not withdrawn her consent for the children to be with father, or that she was requesting that the children be returned.
How long of a period of time would it take to constitute a change in circumstance?
With candor to the court, I think that's an unknown question. One of the cases I cite, I believe the court noted that there had been, over a period of 8 years, motions filed at least once per year for contempt for refusing to allow visitation for different issues that way. And there the court found that that was sufficient. But on the same hand, another case, there were 7 motions filed in total, and although they were resolved in different ways, the court found that that was not sufficient. And so I don't know that it is an issue of there has to be a certain amount of time, but based on the case law, it seems highly unlikely that a 4 to 5 month change, especially under these circumstances where we're dealing with a global shutdown.
Well, ultimately, our standard of review is abuse of discretion. And certainly a misapplication of the law would be an abuse of discretion. But your brief doesn't argue that with regard to change of circumstances. So if the determination is that that consensual period that is uncontested is sufficient for a change of circumstances, how would that be an abuse of discretion?
With respect, Your Honor, our position is that the court's determination of those first 4 to 5 months where the transfer was consensual, that would be subject to de novo review because it's a misapplication of the statute. And I don't think there's any discretion as to the facts for that period of time. And so if the court is inclined to look at those 4 or 5 months, I believe it becomes a legal issue of whether a 4 or 5 month change in location can constitute a change in circumstances as contemplated by the statute. To Your Honor's point, if the court is inclined to look at it through abuse of discretion, misapplication of the law would also be an abuse of discretion.
These are older children, and they expressed an interest in living with their father. Is that itself a change in circumstance? I guess I'm asking, do we know if they expressed a preference for either parent in 2019? And would their expression of a desire to live with dad be a change?
Unfortunately, there's nothing in the record that we have whether the children expressed that. I'm also not aware of any case law to suggest that that could even theoretically constitute a change in circumstances, and that it would instead go to the best interest factors. I think if I could just follow up on one point, and that is the remaining time that father had the children after mother withdrew her consent. I think it was an abuse of the court's discretion to view that in its analysis because it, in essence, rewarded father for his failure to comply with the court's previous directives. It rewarded father for his failure to follow the prior custody award. And it allowed father to essentially create his own change in circumstances and then use that change as both a shield and a sword. And so I would submit to the court that the only relevant time period that can be evaluated for whether a change in circumstances occurred would be the 4 to 5 months that mother voluntarily left the children with father at the beginning of the pandemic. And any time after that should be excluded. One final.
So you're saying that the trial court should not be looking at what each party is presenting with regard to that additional time period, make determinations of fact, and then use those if they found it to be relevant in determining change of circumstances?
No, Your Honor. I'm not saying that the trial court cannot look at that. What I'm saying is that the trial court erred in crediting that time frame to father's benefit. When the children are with father because of his own refusal to return the children, and the evidence is uncontroverted that mother had withdrawn her consent, and I acknowledge that there's contradictory evidence as to the cooperation of facilitating an exchange. Mm-hmm. But when the change in circumstances at that point forward is a father's own doing, I believe it's abuse of the court's discretion.
I think that's the whole point. You're saying it's a father's own doing, but there's conflicting evidence as to who's at fault for that additional time period.
I believe there's conflicting evidence as to who's at fault for cooperating, but I don't think that there's any conflicting evidence as to whether father failed to follow the court's directives and return the children. We have 3 motions for contempt on this issue, an emergency motion, and it's just,
And ultimately, the trial court ruled in favor of father's motion for contempt, right?
That's correct.
But ruled against mother's motion for contempt.
That's correct.
Right? And no error has been assigned to that,
That is correct.
okay?
But those contempt issues are separate and apart from the change in circumstances analysis. I understand that.
Right, but you're arguing that your arguing is rooted in that determination to which there was no error assigned.
I understand that there's interplay between the two, but there's a clear and convincing evidence, standard of evidence that must be established to prove a contempt. So mother's failure to prove contempt is separate and apart from father's failure to comply with the court orders and return the children. And so I do think that the 2 issues have to be analyzed separately.
And counsel, you have about a minute left.
If there are no further questions, I'll reserve the remainder of my time.
All right.
Thank you.
Thank you.
Good morning, Your
morning.
Honors. Marcus Coleman on behalf of appellee, Mr. Caleb Smith, who's the father of the children. So there have been several things here that I'd like to address to kind of illuminate what was happening here. It seems as if much mention has been made of father's refusal to return these children, and that simply isn't the way that this was happening at all. Mother dropped these children off on March 12th of 2020. At some point in April of 2020, a representative from Job and Family Services responded to the home to interview the children and the father to inspect the home. The representative at that point closed that case, stating that the children said that mother left them, they did not know where she was, and they wanted to remain with their father. The home was appropriate, case was closed.
Is that on the record?
That was stated by the trial court acknowledged that. I just happened to, I was a trial attorney, so I happened to know how that happened, but the trial court was aware of that. Your Honor.
And there's no transcript?
That's correct. That's correct. So, and one other thing before I forget, It isn't like the children were without mom. She dropped them off for 5 months, and they just continued the way they were. She had no communication with them whatsoever. So she never called. She didn't check on them. She didn't send a letter, a message in a bottle or anything. Like, they had no idea where she was. She pops up, there's this flurry of activity in August.
Your opponent has argued that this 4 to 5 month period is insufficient to constitute a change in circumstance, and that we need something longer or something more significant to result in a change in custody. And we can understand that the intent of this statute is to avoid children being whipsawed back and forth from parent to parent to parent, right? Can you address this argument, what we would need to constitute a change in circumstance?
Yes, Your Honor. I think that the time frame by itself should also be looked at with the reality that there was no contact whatsoever. So this father did not know where mother was, if she was ever coming back. The children didn't know that at all. So in the effort to make sure that the children had some kind of stability, father had to go forward. And this was something that was put forward to the trial court. So not just leaving the children there, and she's calling every week to check on them. There was zero contact whatsoever between mother, father, and these children. So I think looked at in the totality of that, it looks a little different than simply talking about a time frame, Your Honor.
All right, so is your position, as I'm hearing it, that this was an abandonment of these children?
That is the way that it appears, Your Honor. I'm saying there was a
I'm assuming there's nothing in the record or argued to establish that it wasn't an abandonment, that it wasn't a relinquishment.
Your Honor, again, I know the court will be frustrated by this, being that I was trial counsel. That was addressed at trial, but obviously there's no transcript to evidence that. But that was the contention, is that the mother abandoned the children, and the father didn't know if she were coming back at all, and simply took steps to make sure they could provide some stability. He had difficulty even getting them in school because he was not at that time the parent of record. So those were the kinds of things he was looking to address by filing his petition for custody, and the kinds of things that the court would have been concerned about.
How should we weigh the children's preference for living with their father?
Your Honor, here's what I think about that. Those children are no different than the four of us. We are all the experts on what happens in our life. Those kids are the experts in how they were being treated, the conditions in which they were living with mother. And so when the worker from Job and Family Services asked them where they wanted to stay with father. Police officers did the same thing in August. A Hamilton County prosecutor addressed this matter with them in January of 2021, and obviously the magistrate in the in-camera. They said the same thing. These children were not looking for the fun parent. These children were looking for the parenting parent, someone who could provide stability. So they will never ever forget that she just left them, and not at one point did she reach out to them. The order that grants custody to father also gives mother every other week visitation, every other weekend. She has yet to exercise that. So one of the things that opposing counsel stated is, I know no mother who would just leave, and why would she do all this stuff? I don't know the answer to that question. Here's what I can tell you. I can tell you that these children were dropped off on March 12th. In June of 2020, father goes and files a motion to terminate the child support. Mailing system being what it was during the pandemic, I don't know when mother received that, but you get this flurry of activity in August. I can't say that she found out that he was trying to terminate child support, and that's when she came back. But nothing else kind of fits. It's the gold medal to get custody of your children, but the visitation is at least a silver medal, and she's not sought to exercise that from the moment it was granted to her. So I know no other answer, no other motive for why she's doing all this, as counsel said.
Is that on the record? And I know that you were trial counsel, but I'm talking about what
Regarding
we
the child
can
support.
consider. No, not the child support. The fact that she hasn't exercised any of her visitation since she was granted every other weekend.
Your Honor, that was not part of the record.
Okay,
Was
thank you.
not. I can say that throughout the time up into the trial, the children saw her 3 times. One time in
But
August.
so we don't know that because we are only permitted to look at what is on the record.
Understood. And the court's order, the trial court's order, does reference a couple of incidences when mother did see the children in 2 separate courthouses and walk by without talking to them. The magistrate did reference that which would have to have been disclosed to him by the children during their in-camera. I did not state that to him, so it would have been the in-camera. But that is a part of the court's decision, Your Honor.
Counsel, there are findings in the record that we have in front of us that father was making accommodations to work with mother, whereas mother was not making accommodations to work with father. Can you elucidate what those findings were about?
Yes, Your Honor, I can tell you this, and this was certainly alluded to. There was, during trial, my client testified to this, there was a period at which father called me and said that he was ready to return the children because she called and threatened to call the police or something like that. And so he packed up their things and was waiting for mother to arrive, and she did not. So I do know that he did, in fact, do that. I do know that he stated in court that he would provide whatever parenting time the court was willing to grant to mother, and none was simply sought. So he did make that effort. That's the effort I'm aware of when he took the children, when he got their things together to have mother pick them up, and she did not show. And he did at trial say that he was willing to provide whatever parenting time the court was willing to order.
And was it the case that mother was pro se in the trial court proceedings?
She was pro se in the trial court proceedings. That's
And you
correct.
represented father?
That's correct, Your Honor.
Thank you.
There were several continuances granted for mother to seek counsel, and for whatever reason, she was not able to do so.
Thank you.
So I would say that the older child, as the court's aware, is 18 years of age at this time. The younger child will be 16 sometime this summer. He has been with his father for 3 years, 18 months at the time that the trial court's decision was made. And I think that it would cause this child some irreparable harm should he be removed from that stable situation. And we'd ask that the court uphold the trial court's decision.
Thank you.
Thank you.
With respect to my colleague, I believe father's primary argument is to ask this court to consider evidence outside the record. And when this court looks at the opposite findings of the juvenile court in 2019 as compared to the decision on appeal now, and in consideration that mother was representing herself pro se, if mother was given the opportunity to tell her side of the story with no restraint by the record, perhaps this court would have a different view on all those matters.
Well, Mr. Tritt, since we don't have a transcript, though, don't we have to presume the regularity of the proceedings and that the trial court's findings that, for example, as of the time of trial, father said that mother had not reached out to him since April 2020. Don't we have to presume that the factual findings were correct?
Yes, Your Honor, but we do not have to presume that the court's conclusions were correct.
Right.
And
We reviewed, yes, I understand that, but I'm talking about, the factual findings where the trial court is going through what happened and, finding that the mother walked past the kids and did not talk to them, ignored them in court. So, and that is actually in the judicial entry.
Your Honor.
So, with those findings, since we do not have a transcript, I understand that your client was pro se at the trial court, but without a transcript, what are we supposed to do with that?
I believe the answer is to focus on the legal question of whether there was a change in circumstances. And I think that question is clear, that under Ohio law, a 4 to 5 month change in residence simply cannot constitute a change in circumstances. And so once that's established, we never get to the other factors that the court discusses, whether mother acknowledged the children, because those factors are simply not relevant to whether a change in circumstances occurred in the first place.
Is the lack of a transcript due to the economic burden of producing one?
It's not in the record, but yes, Your Honor. If there's no further questions, I yield my time and ask this court to reverse the custody modification.
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission. We will issue a timely decision. Have a wonderful afternoon, and thank you both for your advocacy as well. Thank you.